What if I told you that there's a document that puts debt collectors on notice and shuts them down without a fight? In this video, I'll break down how Affidavit of Non-Negotiation can legally block collectors from transferring or enforcing a debt and why it works when done properly. I've studied commercial paper law, debt collection practices, and affidavit remedies, and I'm going to show you how to assert your position with precision. Now, before we dive into this video, this is not legal advice. This is not financial advice. Make sure to do your due diligence. You dig what I'm saying? Number two, thank you guys for watching. If you are brand new to the video, make sure to hit the subscribe button. Make sure to hit the like button, okay? We are trying to be at the top of the algorithm, or will be at the top of the algorithm, because we're talking about things that nobody is talking about, all right? Once again, thank you for watching this video. Let's dive straight into the video. What exactly are we going to be talking about, and what is an affidavit of non-negotiation? You dig what I'm saying? Now, we talked about conditional acceptance. We talk about affidavit of truth. We talk about presentments and things of that nature. But there's a little known affidavit called an affidavit of non-negotiation that literally says that, hey, what I am about to tell you guys is non-negotiable. Okay? And this is not a tool that one should say, hey, this is going to just completely wipe away my liability. No, this is a start and a piece of the process. And again, this is something we haven't covered on this channel. Okay? So make sure you watch all the way to the end, because we're going to be talking about some key legal foundations behind this affidavit, how to use it properly, and how to put yourself in a position to where, okay, look, they gotta start respecting your gangster. You dig what I'm saying? So let's dive straight into it. Now, what is an affidavit of non-response? Okay, an affidavit of non-response is a sworn statement stating you do not authorize further negotiation, transfer, or enforcement of the alleged debt. All right, it's just that plain and simple. Okay, and when you start to initiate this action, this is typically used to rebut claims that the debt is an active commercial instrument. So if that is the case, okay, and I am now on the opposite side of you utilizing this of a commercial instrument, okay, then you can't personally use it as an asset, okay? Because think about it. If you focus on debt being a liability, rather a commercial instrument, now we are focused on debt being a fixed obligation to repay, okay? So unlike traditional commercial instruments that are used for active trading, now we can start to look at debt as a fundamental liability, okay? That essentially must be repaid with interest over a specific period. All right. Now, if they decide after you send this to trade it, you are now moving fraudulently in simplest terms. OK, because now if we shift that to the obligation to repay as a primary characteristic, then the repayment method and schedule are specified in a binding contract, highlighting that the primary focus on repayment rather than the instrument's potential for commercial use. So if I give you this, you can now not use it for commercial use without my consent, okay? And here's where it becomes so powerful. If you do, or if you already have, where do you think that you will land? Do you think that you'll land in a favorable position, okay? So now you have to then tell me that, okay, we sold it, or we use that as a commercial instrument. All right. And when you do this, especially when you create an affidavit and they do not respond to it, based on the principle that your silence implies consent, but a sworn affidavit removes consent from the equation. Okay. So they are able to sell these things because we are silent typically. Right. And in some way, shape or form, we give away our, we waive our rights to even have consent when we write in that original loan agreement. We unknowingly give them security interests. So when you then send them a affidavit of non-negotiation, you are now putting it out there that, hey, it's not even about, I never gave you guys consent to transfer this. OK, I'm putting that out there. So now before you transfer it, you have to go through me. So collectors rely on your inaction, and this affidavit takes their ability to act. So what happens is now if I send you this non-negotiation affidavit, and that means you cannot transfer it. And I have evidence of me telling you not to do that. Okay? So I want to just talk about a couple of things. So the key laws that back up the affidavit of non-negotiation is number one, UCC 3-302, which essentially is the definition of a holder in due course. And a holder in due course can't enforce if they knew of dishonor or defenses, okay? Also, it goes hand in hand with UCC 3-305, because if this person, right, is not the holder in due course or doesn't follow under this subsection of what a holder in due course is, then you have a right to assert your claims and challenge and rebut their claims. Okay. So when you send a affidavit of non-negotiation, now it is challenging them for them to prove that they have lawful standing, right? That they didn't transfer, that they didn't sell it without your consent. Because if they did sell it without your consent and you literally challenge them, right, just to make sure that they had that lawful consideration or that they are under legal standing to collect on a debt, and they cannot prove that they never transferred it without your consent, they are now not the holder in due course. You can defend yourself under UCC 3-305 against a person that's not the holder in due course attempting to collect on a debt. And then when you dive into the aspect of you being able to demand presentment under UCC 3-501, essentially says that when you present them with the presentment, you say, hey, look, man, I want you to provide these documentary evidence that will prove your legal standing, and they do not provide it, they are actually dishonoring you according to a contract. Okay, you actually create a contract when you demand presentment. They must cease collection, stop negotiation, what may have you, and present whatever information you have demanded for. Okay, and then when you look at UCC 1-308, just for your reference, you reserve your rights without admitting liability. And that's the whole purpose of people putting the 1-308 at the bottom of their signature, or without prejudice or under protest, things of that nature, so that they don't waive their rights and admit to being liable to whatever the alleged debt is, just because I'm sending you a letter saying that I don't want to negotiate this anymore. Okay? You are essentially telling the system that this paper is not valid, not negotiable, and not payable until you can prove it. Okay? Especially on the aspect when companies securitize your loans or securitize your contracts before you even get a chance to, before you even know it, right? They may do it on the consummation of the loan itself on the first couple of days. They may do it within the first 30 days. All right? So when you think of what the affidavit does, and I do have this affidavit in my complete debt guide. If you got this far, go ahead and click the subscribe button, click the like button. Number two, what I'm talking about in this very affidavit is included in my complete debt guide and step-by-step instructions on how to use it within the YouTube section or the YouTube folder of the drive. Okay. When you're looking at this affidavit of non-negotiation, number one, you'll start it off with a simple affidavit of truth, right? Saying things like, I, Jane Doe, a living man, woman, declare under penalty of perjury under the laws of the United States of America that the following is true, correct, and complete to the best of my knowledge. Number one, I am not in possession of, nor have I endorsed or negotiated any instrument or agreement alleged to support the claim made by debt collector. Number two, no lawful, valid, or verifiable contract exists between myself and the debt collector. It's impossible for a valid contract to exist between you and the debt collector because, number one, you're a living man or woman, and they are considered a dead entity. They cannot even contract. That's one. But even two, if I see that contract as something that's not valid, now they have to honor that. Now they have to prove that it isn't valid if that is my truth. And it could be valid based on the fact that they didn't disclose information to you. It could be invalid based on the fact that they sold it or securitized it. It could be invalid on many factors, and this is why you would send this letter in the affidavit of truth. Number three, I hereby declare that any purported negotiable instrument or agreement is considered null, void, and non-negotiable by my notice. Okay? Really making a key truth and enforcement that they will have to then prove is not true. Number 4, the affidavit serves as a formal notice that I do not authorize negotiation, collection, or transfer of any such instrument. Okay? When you put these things out there and they then do it anyway, that is a violation of your rights. This affidavit is made to assert my rights and record my position. All rights are reserved. UCC 1-308. So then you go into part 2 of it, which is the notice directly to the debt collector included with the affidavit, saying, encloses a sworn affidavit of non-negotiation. This is my document formally notifies you that I do not acknowledge or authorize any collection, any negotiation, or enforcement of the alleged debt associated with this account. Account number. Any continued collection activities without proper legal standing will be construed as a willful violation of the Fair Debt Collection Practices Act, 15 U.S.C. 1692, and the Uniform Commercial Code. Now, you are hereby directed to cease and desist all collection efforts until proper and lawful validation is required. Okay? Very simple letter. Obviously, you can pretty much create your own, right, based on that. But I'm essentially saying you must not collect. You must cease collection activities until you can prove that, until you do the proper validation. And if you don't, case closed. Now, here's what that affidavit does. Number 1, this forces any collector or third party to prove authority, standing, and ownership of a debt. Okay? Specifically when we are saying that, hey, look, something is null and void because I think that it's not, you have authority, standing, or ownership. Now they have to prove that. This is the aspect of shifting the burden of proof. And then we dive into notifying all the parties that the debt is in dispute. You do not authorize negotiation or sale, and you object to the enforcement without validation. So what they'll do is they'll assume that you are okay with being alleged debt being enforced, whether it's proven or not. So it's important that you utilize this against them. Okay. Once filed, this becomes evidence that you objected in writing and under oath that, hey, you cannot enforce this. Hey, that you cannot transfer or sell this. Okay. And if you do, you must notify me. If you do, you have to ask for my consent first. Okay. This could be a very strategic way that when you get into any type of contract, you could send this right away within the first 30 days. Now, I'm not making any promise that this can, this will immediately help you, but this could serve as a different level of positioning when it comes to any of your contracts and loans. Okay. So here's how to create and use it properly. Number 1, draft it as a sworn and notarized document. So you want to make sure that when you draft it, you can follow the words that I said. You can get the template from the Complete Debt Guide and you can use it as an educational tool. But whatever you decide to do, make sure you write it up and you get it notarized so that now it has a witness to it. You want to include your account number. You want to include a statement denying negotiation or transfer of rights, declaration that no valid contract or consideration exists. So putting it out there that, hey, look, I don't think that this was a valid contract and I don't think there was lawful consideration based on X, Y, and Z. And they will have to prove it is. Okay. Next, you will send certified to the collector, the creditor, and any known third parties. And as an optional thing, you can record it with your county or state. When you start to put this paperwork together, it now puts panic in their minds. Okay, they start to maneuver differently. Okay, what is this person doing? And they may do something like, oh, well, we have to cancel this entire contract and pick up your vehicle, or cancel this entire truck contract and foreclose on your home. But the law doesn't keep you from asking them to prove they have legal standing. They'll make you look like and seem like you're doing such a wrong thing, but the reality is you're doing what you are supposed to do. You are deciding not to consent. If you overcome my consent, then you are violating my rights, and that right there could be a civil offense. And if we're talking about the Truth in Lending Act, that's also a criminal offense. Okay? If you tell me, oh, you can't do that, you are giving me false and misleading information. And according to 15 U.S.C. 1611, that right there is a violation of my rights and a criminal act. You're going to be in prison no less than $5,000. and fined, okay? So here's what happens after you send it, okay? Many collectors will back off or pause the collection process, which is good, which is what you want, okay? But still be on the lookout for the type of mail that they send you, okay? Number two, some may challenge. As a matter of fact, expect it. People do this and don't think that they're going to be challenged. And when they do get challenged, they sit there and they throw their hands up and they get upset. Nah, man. I mean, this is you got to love the game. You got to love the hustle. Stop thinking that you're going to send a letter and it's just going to magically work for you, or they're not going to challenge you, or you're not going to get any pushback. You think if you decide to not, if you don't want to get any pushback, then just pay your bill. But if you want to go against the system, understand that there's going to be a challenge. There's no growth without any pain. There's no growth without any struggle. Struggle before success. Shout out to my man, Chief SBS. You dig what I'm saying? But if they do challenge you, you send them a notice of fault and dishonor. Hey, look, you have created a fault. You have dishonored me, but I'll give you an opportunity to cure. So you giving them a second chance to not dishonor and not allow you to assert your rights. Number two, if they don't, then you take them through, you have them defaults, because you create a contract when you send them a presentment according to UCC 3-501, where you say, hey, look, when I sent you this presentment and made a demand, you now have to present that information to me. Okay? Because there is a contract being formed, you have to perform by presenting this information. Now, if you don't present this information, guess what? You have defaulted on this contract. So forget whatever contract you're going to say I defaulted on. You defaulted on your promises. You didn't exercise your duty according to whatever contract that I'm determining was null and void and not even a legal contract. Okay, either I was coerced, held under duress, or whatever the case may be. But then we dive into the full administration process. The administration process is literally that. The initial notice, affidavit of non-negotiation, affidavit of truth, you stating your claims, and then usually if they back off and pause, great. But if they don't, guess what's going to happen? You send them, you take them through the administrative process, opportunity to cure, notice of fault, estoppel by acquiesce, however long you want to go. Administration is literally private, is a private process where you get your own private remedy first. Now, just because you get private remedy first, it doesn't necessarily mean it's going to be seen. It's not going to be seen in the public eye. So this is when you take your private remedy and you go to court with it. If they try to take it far, if they try to continue to collect, if they continue to violate your rights, if they try to sue you, you have this private remedy. You have this private documentation. You dig what I'm saying? And then number three, a potential claim for damages. Okay, this is when we talk about understanding where they have violated your rights, whether they gave you, they violated the Fair Debt Collection Practices Act and didn't give you proper validation, but continue to collect. That could be $1,000 or more. When we talk about the aspect of them maybe even misrepresenting, right, the information, that could be a direct violation of the UCC. If you're asking them to provide documentary evidence about that loan or whatever the case may be, and they do not provide it, that's a direct violation of 15 U.S.C. 1601, or as a matter of fact, I'll just say the Truth in Lending Act. And then if they give you false and misleading information, making you think that what you're doing is wrong, that right there is a violation of 15 U.S.C. 1611, which means that right there, their lies is actually a criminal offense. Okay, so the reason why I'm able to talk like this is because I'll go and I'll study the laws on a repeated basis to the point where I can cite these laws. I can literally go walk into a dealership, have a conversation with the debt collector or whatever the case may be, and they're going to look at me and say, are you an attorney? No, I'm not, but I'm an attorney in fact, okay? Because I'm representing my straw man. I'm making sure that you don't take advantage of me. And I don't have to be an attorney to know the laws. Most attorneys, they are bound by the bar, so they cannot do much, or they don't really care too much about going against the system. All right. They're just going to do what was in their job because they're going to get paid regardless. Okay. Now, obviously they want to win. They want to get the award or whatever the case may be as far as sues, because that's a bonus on top of them already being paid by the hour. But, you know, The thing is, collectors know the game and you don't, and this is why they take advantage of you. They know that you're not going to take it this far. They know you're not going to send them any letter. And again, whether it's you're sending them a debt validation letter, whether you're going to send them a affidavit of non-negotiation and tell them, hey, you cannot transfer this and then come after me for the debt. If you do transfer it, then or have already transferred it, then this makes this contract null and void because I never consented to it. If I start to switch up things and use affidavits, they know you know it too. And this is where they start to panic, okay? Because they have to be very strategic about what they say and what they write to you. So here's what will come next. They may even call you and say, well, I don't know why you sent that. That right there doesn't make any sense. Okay, well, send it to me in writing that it doesn't make sense. And I want to make sure that your legal counsel does that. When you start to hit them with this stuff, they'd be like, damn, okay. And I dare you to send me some lies in writing so that I can be able to call you out on it. And I'm going to use this evidence against you. See, I'm not afraid to do that. I'm not afraid to take you to the task. Trust and believe I'm not. Okay. So be very careful. Be very strategic about what you plan to do. Okay. So I wanted to do a quick video about the affidavit of non-negotiation, that full pack, and how to use that strategically with your other letters and your other forms. This is something you can include in the packet, right? I always say, look, put as much information in a packet so that they cannot say, oh, well, so you're not sitting there like having to add things over time. And you can. It's okay. It's literally your administrative process. When they respond to you, be willing to respond back. And don't just give them a generic response. Read what they say and literally rebut them point for point. Okay? Understand the process, overstand the process, because it's not about, oh, you wrote this letter and I sent this template, I sent that. And I'll ask you, okay, what did you send them? What did you specifically ask for? What was your claim? Oh, I sent this and I sent that and they never responded. Well, do you know that you're supposed to send them a letter? Do you know that you're supposed to challenge them directly? Do you know that? Or are you just gonna just say, oh, well, they didn't comply? Well, there is a law that says that if they don't comply, that is willful non-compliance. Or if they neglected it, there's willful negligence or knowing negligence. That's $1,000 count. Okay? So you tell them that this is where they have violated your rights. You tell them that directly. Have them respond to that directly and see how they respond. All right? The thing is, they want you scared. They want you silent. And once you file an affidavit of non-negotiation or any type of affidavit challenging them directly about what they're going to do about that note, or have them prove their legal standing, you become the one asking the questions that they have to answer before you even pay a dime. Okay? Be very strategic about this. Remember, this is not legal advice. This is not financial advice. Consult any attorney, and moreover, make sure to do your own due diligence. You've gotten this far. Tap in with the Complete That Guide. I have that affidavit power pack in the Complete That Guide. You become an affiliate once you tap in with the Complete That Guide. Number 2, if you want to work with me one-on-one, the link will be in the description. It is a very strict application process. If you don't meet the criteria, then it's totally fine. I will direct you where you need to go. Okay? But I help people fix their credit, get funding, and also help them make money in their online business or credit repair business. If you have a credit repair business, I can be able to help you grow and scale that to 5 figures or more a month. Okay. Lastly, if you want to work, if you want to tap in with me on a consistent basis, follow me on Instagram. Follow me at biz.nick. I just got on Snapchat, but I probably won't put the link in the description just yet. I'm going to do some organic growth there. Tap in with me on Twitch. We're at 162 followers on Twitch. Tap in on Twitch, so that you can see the live breakdowns, Q&As, really chop it up with me. I may do a multi-stream YouTube and Twitch, but I probably won't. Once we start to grow on Twitch, I'm really going to focus more on Twitch. So make sure you guys follow the Twitch down below. Okay. Remember to like, share, turn on the post notifications so that you get a video every single time we post, so that you get a notification. Number 2, tap into the Instagram broadcast channel, because that's where I post the updates for the YouTube videos. And if you've gotten this far, comment the word discharge. I love you guys, and I'll see you in the next one.